This is the ERISA Edge, bringing you fast, insightful, and actionable advice on fiduciary responsibility and retirement plans. I'm Don Jones, and our meaningfully different discussion today will be on the Amicus brief provided by the Office of the Solicitor General for the case of Pizzaro versus Home Depot. The Home Depot case at this point has already gone through both the federal district court and the appellate court. And in both cases, the courts ruled in favor of the defense, which is the plan sponsor. So it was then appealed up to the Supreme Court. Approximately 10 days after finishing the Cunningham case, the Supreme Court invited the Solicitor General to reapply the amicus brief, indicating that if you send it, we will react on it. We'll take this case. Now, the case is much like almost every case under ERISA. It is abuse of the plan fiduciaries and the 402 name fiduciary, not providing fiduciary governance or fiduciary care to the plan participants and their beneficiaries that meets highest standards known to the law. The same arguments almost that the Cunningham case is about. How much does the plaintiff representing the plan participants and their beneficiaries have to plead in order for the judge not to dismiss the plan and proceed with discovery? And in the Cunningham case, the Supreme Court was very clear that there were really only three things that needed to be done. That you had a service provider or service providers who you had a contract with, and those service providers were being paid out of plan assets. And because of ERISA 408b2, it is what is called a prohibitive transaction, a breach, to be paid out of plan assets. The Supreme Court unanimously, 9-0, said the judge needs to take this case and not dismiss it. Now, how is this case different? They had lost the plaintiffs for the Home Depot plan, that both the district court and the appellate court insisted that the plaintiff attorneys had to also include in their pleadings what's called causation. Cunningham made it clear they didn't have to do that. So I went back and read the Office of the Solicitor General's amicus brief on the Home Depot case. Justice Sotomayor said and reminded everyone that ERISA is based on orthodox format. Read it, understand it, and do it exactly. Not like you wish it was, but what it said. Then she said, and it's also black letter law, the ink is dry. Don't keep bothering the court. We've already made these decisions. But they cited different cases that were so powerful to suggest that the courts would not rule like they did. Tibble versus Edison International, 2015. Here, the Supreme Court made it clear that ERISA is based on the common law of trust. To me, ERISA is the what, and the common law of trust is the why. You cannot be a successful practitioner under ERISA until you know that your handbook is the restatement. Under Tibble, it says, trust law is the bedrock of fiduciary issues. And when ERISA is not clear, you must use the restatement. Shaw versus Delta Airlines reminded everyone that the duty of the Department of Labor was one exclusive duty: protect the participants and their beneficiaries. In fact, if you read under ERISA 44A1A, it says exclusively focus on that participant and their beneficiaries. And the minute you take your eye off that, you've taken your eye off the ball. ERISA 409, which states, once the plaintiff has established a breach, the burden to provide the innocence shifts now to the defense. Remember, both the district court and the appellate court was insisting that the plaintiff had not proven causation. You can't be any clearer. They don't have to prove causation. Then they list the restatement of law, third, and quote what it says. This is section 100. Once the plaintiff has established a breach and a loss, be it plausible, then they must go no further, and the burden then shifts to the defense. They then cite a case called Beckett Industries, where it says, and again I'm paraphrasing all these, the court does not take kindly the argument by the defense that once we go to the area of law called causation, the defense just throws their hands in there and says, it had no effect. It did not affect the participants. Well, you must prove that. You can't just say it had no effect on the participants, because most likely it did. The estate of Stetson says the innocent participant did not create the breach. They are not the fiduciary, and they need not to plead the cause or the effect of the breach. That's up to you, the plan sponsor or the defense. ERISA is very clear. Once the money goes in the plan, it is the participants. Even employer money. They are powerless and they're innocent. Brotherston versus Putnam Investments. Under trust law, burden shifting, meaning the plaintiff no longer has to do anymore, happens once, not later, but once the plaintiffs have established a plausible breach has occurred. They used a case called Willett versus Blue Cross Blue Shield of Atlanta. Well, the Solicitor General made it very clear. You're not even using a right case. This case is about health insurance in an ERISA plan. It's not about retirement benefits, and it doesn't even go into causation. I mean, you were just throwing something to the wind. And guess what? The court believed it. So what's my prediction? Well, I think it's another 9-0, because just read the law and apply it. And clearly, all the plaintiff needs to do is establish there is a contract. Here's the contract, Your Honor. Establish that the service provider is being paid out plan assets. Establish under ERISA 408B2 that could be a prohibitive transaction. Then finally, let the plaintiffs simply establish those three things. And as they reminded the judges in the lower courts, this is what you're to do. You're not to dismiss the case. You're to allow it to go to discovery, period. And the plaintiffs need to do no more. We continue to see cases that the defense will not accept what's there. And as was said in the Cunningham case, if you don't like the law, work on changing the law. But all we can do is rule on the law. Orthodox format, black letter law. That's the safest way to protect your clients or you as a plan fiduciary. Thank you for watching the ERISA Edge. If you found this helpful, be sure to follow Fiduciary Wise for more insights on fiduciary responsibilities and retirement plans. And please stay tuned for our next video.